To begin with, perhaps a steering statement. The principle of res judicata is so fundamental that one would believe that it is a consolidated and well understood concept of law. Well, this statement, rather controversially, but is not particularly true of EU law. When one thinks of res judicata and EU law, one can envisage a myriad of different venues. Res judicata is, of course, the general principle of the legal order of the EU. On the one hand, this means that judgments rendered by the Union courts must have res judicata. This also means that res judicata is an autonomous concept of EU law in certain areas. For instance, our area of research, judicial cooperation in civil matters, also encompasses an autonomous interpretation of res judicata. However, res judicata is also the fundamental principle immanent to all member states and found in the national procedural laws of member states. And this principle often conflicts with EU law. For instance, a judgment is rendered which infringes EU law, and this judgment then becomes res judicata according to national law. The question arises, how binding or which preclusive effects can such a judgment in conflict with EU law have? Now, if I would take a step back, I mentioned that res judicata in EU law is a general principle, and each EU law general principle is derived from the general principles common to the laws of the member states. This must then evidently also mean that res judicata of EU law is derived from the common laws of the member states. Now, as Professor Keresztes and José previously mentioned, there was a rather exemplary research done by the British Institute on International and Comparative Law, which categorized the national conceptions of res judicata basically into three categories. We can see them on display here. However, I will not burden you with explaining each one of them. What is important here is that the Court of Justice of the EU seems to favor the French interpretation of res judicata. That is, res judicata, which finds its objective identity in the so-called triple identity test, parties cause objet, and that the CJEU interprets that res judicata is basically confined to the operative part of judgments. Now, all of these conclusions are derived impliedly. They are derived through a set of case law, which is known as the negative res judicata effect, when the Court of Justice basically observes how far a preclusive effects of national courts can go when those national courts, which are in fact res judicata, contain an infringement of EU law. Are they then still binding, or do they still produce preclusive effects? I will advance on the hypothesis produced by Kornezov in his 2014 article in Common Market Law Review, which basically advocates what I stated before. Res judicata in EU law is based on the French triple identity test and limited to the operative part of judgments. How do we know this? Well, if we look at the watershed case of Köbler. Mr. Köbler, this is a very famous case in Austria, was a university professor who applied for an increment in salary. He was denied by the administrative court this increment. This judgment by the administrative court then became res judicata. Mr. Köbler alleged that this is a violation of his EU rights, and he then filed suit for damages against the Austrian state. And the question, of course, arose. Would a positive rendering on that damages impliedly also declare that the previous judgment, which has become res judicata, is unlawful? A lot of member states stated that such an action for damages should not be permitted, specifically because of the res judicata effect of the first rendered judgment. Well, the court resolved this issue by basically stipulating its own autonomous conception of the identity of judgments. The court stated that the first and the second judgment do not share the same purpose and do not necessarily involve the same parties. We see two elements of the triple identity test here. That is not the same parties. First was the university, and the second was the Austrian state, and not the same purpose. The first served to invalidate the decision on the increment of salary, and the second one was on damages. The court did not make reference to the triple identity test, to be exact. However, it would seem that it followed suit of the Advocate General's observation. The Advocate General stated that according to the prevailing traditional definition of res judicata, that is the traditional definition in EU law, the latter should be defined on the basis of the threefold identity. Now, as we see, the Advocate General and later on the court basically favor the French interpretation of res judicata. And as I already stated, the court did not make this clear, however, and it did also not make any reference to any other national concept of res judicata. It developed its own autonomous reasoning herein. So we can only impliedly then gather that the court favors the triple identity test. Be it safe to say that the third element, that is the legal basis or the cause, was not explicitly mentioned by the court, but the two other elements are present. Now, the next landmark case is the infamous case of Lucchini. Mr. Lucchini basically claimed suit for a loan. Now, as it turned out, during those proceedings, the European Commission issued a decision finding that that loan constitutes incompatible state aid. Now, what does this mean? Incompatible state aid means that such state aid cannot be implemented, because if it is implemented, it becomes illegal state aid and it must be recovered from the recipient. Now, even though the EU Commission made this finding, this did not stop the Italian Civil Court in rendering a condemnatory action for the loan. The competition authority was requested to actually pay out the loan, and Mr. Lucchini actually obtained thereafter the incompatible state aid. What this means is now that the situation is very hard for the Italian state. The Italian state has to recover that aid which was paid to Mr. Lucchini. But we already have a res judicata decision on that aid. And of course, the question arose, would these two claims then be precluded? Would the claim of the Italian state to recover the aid be precluded by the first judgment on res judicata? The question was made harder by Article 2909 of the Codice Civile, which precludes not only the reopening in a second set of proceedings of pleas in law which have already been expressly and definitively determined, but also precludes the examination of matters which could have been raised in earlier proceedings but were not. And this was exactly the case in the first proceedings where Mr. Lucchini claimed for the loan, because during those proceedings, the EU Commission rendered its decision on the incompatibility of state aid, and this could have been used as an objection in those proceedings. However, neither the court made any ex officio reference to EU law, nor did any of the parties make any reference to EU law, that is to say, state aid law. And judging by the very well, it seems that the Italian regulation is very encompassing of res judicata, and it does not extend only to the operative part, but also to the so-called decisive reasons of the judgment. The Court of Justice proceeded, wherein it basically criticized the broad understanding of res judicata in Italian law, and it decided that in such a case, the national rules on res judicata must be set aside in favor of EU law. Now, how did the court reach such a conclusion? Well, this is a very restricted exemption, because the principle of the primacy of EU law was violated, which is basically a conflict of rules law. Every rule of EU law should have precedence over every national legal regulation. However, if we were to derive that fully, this would basically mean that every judgment would be devoid of res judicata effect. And the CGU is aware of that. This is why it strictly limited this conception of primacy over res judicata to the case where there is basically a blatant violation of exclusive jurisdiction between the member state and the EU Commission. A very similar case was Klausner-Holz, rendered in Germany. However, this time we did not have any EU decision rendered by the Commission. Klausner-Holz first brought an action for positive declaratory relief, which he obtained, that he has a claim, and then he brought a condemnatory judgment. And now the defendant raised the point of law that the object in question is illegal state aid. And the question again arose because Klausner-Holz already obtained a valid positive declaratory action. And the German rules, paragraph 322 of the Code of Civil Procedure, precluded then raising such an objection, or at least having it taken into account, exactly because of the res judicata effect of the first judgment. Now, the Court of Justice herein laid out the algorithm, more specifically, as to how to deal with such situations of violation of EU law. Firstly, it reiterated the importance, both in the legal order of the EU and the national legal systems, of the principle of res judicata. Then it stated that EU law does not always require a national court to disapply domestic rules of procedure conferring finality, even if to do so would make it impossible to remedy, basically, to remedy a breach of EU law by the decision at issue. Now, a significant obstacle, however, which is very fundamental, which fundamentally breaches EU law, will, however, produce such an effect. Therefore, violations of EU state aid law, for instance, are of such magnitude that they require the disapplying of national rules on res judicata. However, this can also be resolved at an earlier stage. We do not need to disapply a rule if we can consistently interpret national rules on res judicata so as to interpret them that they do not involve a preclusive effect if a point of EU law was not raised when it could have been raised and then subsequently produced a breach of EU law. This was confirmed later on in Fallimento Olympic Club, that the principle of effectiveness of EU law is also not absolute. So on the one hand, we have the national procedural autonomy of the member state, which gives the member state right to decide on its own rules of res judicata, and on the other hand, we have the effectiveness of EU law. And when weighing these two principles, regard must be had to the protection of the rights of defense, the principle of legal certainty, and the proper conduct of procedure. When we weigh all of these principles at both the EU level and at the national level, we see that the national court has to conduct a very hard, a very complex, algorithm to come to the conclusion of whether to disapply rules on res judicata or whether an interpretation, a consistent interpretation with the rules of EU law and res judicata will suffice. These are competing principles, which will then provide an answer as to the negative or to the positive. And I do not have enough time to go into details, but it is a very interesting topic, to say the least. Now, the hypothesis, as I already mentioned, of Cornezo was that the triple identity test is pervasive in EU law, and that the res judicata covers only the operative part of judgments. The latter conclusion was reached from the interpretation of the Lucchini and the Fallimento Olympic Club, where the Italian rules on res judicata extending to the decisive reasons of the judgment were deemed basically too broad. And Cornezo then attempts to reconcile this observation with the observation of lispendence under the Brussels regime, which also features the triple identity test. However, we know from, at least from Goethe Allgemeine, but already before from Wolf v. Fox, that res judicata might also include other elements. Specifically in Goethe, the concept of res judicata also attaches not only to the operative part, but also to the ratio decidendi of that judgment, which is also another very interesting topic, which we will have to reserve for another time. And another problem which here also arises is that in Goethe Allgemeine, the Court of Justice made reference to its own jurisdiction. That is to say, how the Court of Judgment applies res judicata to its own judgments. And that is that res judicata extends to the matters of fact and law actually or necessarily settled by the judicial decision in question. So we have these competing autonomous concepts of res judicata in EU law, and it will be truly a tremendous effort to try and reconcile them in the future of the Court of Justice jurisprudence. Thank you.